I keep telling him everything arises by contract and agreement, and he keeps believing that common law is not a contract or an agreement.
Well, basically common law arises out of custom and usages. Customs are agreements, whether written or otherwise. And usages arise from the customs, which are the agreements to be able to treat with one another, whether that one another is individual to individual or whether individual to unlimited infinite another in relationship to society or otherwise, multiple societies. So the common law, in the old way of understanding it, it was the common law of the land. Well, the land was usually ruled by the customs and usages, which are agreements to treat with one another in relationship to how they would treat possibly with one another or foreigners to the land. And in respect to that, that's how other customs and usages or other applicable rules and regulations, the difference between common law of the land and the common law of the sea, developed. And those were agreements when you're off the land, how you would treat, and those were agreements when you're on the land, how you would treat. But still, the whole point is, it's still agreements. You cannot say it's not contract, because otherwise, how would you treat with one another to acquire services and goods from any society or each other to perform according to the obligations to acquire such services and goods? This is nothing more than contract law, period. So, when you take a look at the Constitution...
Can I stop you right there a second?
Sir?
Can I stop you there a second and address this issue about trespass that came up in relationship to someone stepping on my front porch?
Oh, okay. First of all, they're making an assumption that they have permission to do that, okay? And that assumption or that permission to do that is only going to be questioned when there is an agreement either to disallow it or to allow it. And it is allowed in the interest of peace until notice is given otherwise. But that still deals with agreement. And if there is no agreement to allow it or to end it, trespass arises under law of custom and usages. Some may refer to it as common law, some may refer to it as statutory, some may refer to it however they wish. But it is still contract agreement between one and another, or how many others that may be involved in the agreement to allow or to disallow someone to approach another. You know, and breaking the closure, you know, someone who enters your property without permission, that is trespass, because they don't have permission to do it. They don't have an agreement to allow them to come, period. Now, they may not know about any condition in relationship to agreement, but once they get that notice, and notice is, you know, when somebody says, hey, you're not supposed to be on my property, okay, that's the agreement unless you get permission. Now, if you violate that agreement or that contract to keep the peace, you have a violation of the peace. And that is a breach of the peace. It ends up in a violation of contract. You do not have permission to be here, or whatever. But it is still an agreement. It arises under the law or the science of right reasoning, which is how we develop customs and usages to keep the peace. That's as simple as that.
But the customs and usages themselves were all developed by agreements and contracts.
Absolutely. Nothing has ever arisen otherwise, unless you're dealing with the state of nature where chaos rules.
I know. Well, that's exactly what I've tried to convey this in any number of ways, and I keep going back to this thing that it's an agreement.
Okay,
Even what you're saying with common law, customs and usages were developed by agreements.
So what does the law of the land mean?
Well, the law of the land would be the customs and usages that are...
Based on what?
Well, the agreement of the people within the society.
And exactly. Many centuries ago, they would like to say it's unwritten, because the common people did not know how to write. So these customs and then usages came out of such eras, and it was known as, let's take, for instance, the common law of England, okay, which they openly say they have an unwritten constitution, but, you know, believe me, they don't. They have a written constitution. You know, they just call them different names, like charters and so forth and so on.
Right.
You know, like the Great Charter, known as the Magna Carta, which means carta meaning written letter, okay, from the king recognizing the rights of the people. so forth and so on. It's an agreement with the king, with the subjects. No longer do this, or I will do this, and so forth. So they have a written constitution or charter or whatever you want to call it, but it is a contract. And if he violates it or they violate it, then there's actionable cause related to the law or to the agreement. So the law is the agreement. That's as simple as it gets.
And that's the whole thing about you can't breach the peace unless somebody has agreed over what peace is or is not.
That's a contract, a meeting of the mind.
Exactly. So whether I'm fully researched and versed in this thing called common law, I mean, you and I talked about this, all these different venues of law are nothing more than a way to divide how people are going to treat contract.
Yeah, and I disagree. It leads to chaos.
Exactly. I mean, that's my whole point about this. Can't you read the document? The document says this, or the common usage and customs that we have agreed upon say this.
And even the Constitution, if you want to openly recognize this, that the law
Which Constitution?
Is superior.
Which Constitution? The ones in Rome or the ones in England or the ones
that most people know here, the U.S.
Oh, yeah, that Constitution.
You understand under Article 1, Section 10, it says, and they shall not impair the obligations of contract.
Right.
So do they not recognize that contracts are superior to the Constitution?
Well, not only that, they would be superior to custom and usage.
Absolutely.
Because the contract itself...
individual rights to contract to do whatever.
Right. Because you and I could sit down here and between the parties actually agree on a contract which would be a variation of agreement of the custom and usage.
That's what led them to adopt Article 5, Section 116. Okay?
Right.
To prove the point. My whole point is for people who are locked in semantics, they must realize, or at least willing to realize, to look at the facts and the reasoning behind what makes a society. It is nothing more than its customs and usages, which have been developed for billions of years or 2 minutes. It doesn't matter. You know, it's all by agreements. You're going to act this way, I'm going to act this way. And we have to set up the institutions when there's a breach to how we've agreed to act. And these are called forums, courts, or whatever you want to talk about it, and agencies which are used for arbitration in relationship to settling matters that may arise in relationship to such breaches or otherwise to keep the agreement, or otherwise known as to keep the peace. The peace is the agreement. The peace we are talking about is the individuals coming together for whatever services and goods they're trying to acquire in commerce or otherwise to be able to obtain whatever is necessary to sustain their existence.
Can we get into another point about what you just said about the Constitution?
Sure.
I keep hearing about all these amendments.
Right.
And, of course, I keep looking at the contract.
Right.
Being that it was we the people of the United States.
The opposite term would be of. People of.
Right. Of the United States.
And adverb would be they did something for.
Yeah, they did something for the United States of America.
Correct. They became constitutors under Article 6.
Clause 1.
Exactly. Assume the debt that the former United States of America had become indebted thereby to. That's how the Treaty of Peace arose. They went and negotiated, to pay the debt for the United States of America. That is, the individuals who were the plenipotentiaries representing the United States in Congress assembled. It did not say the United States of America in Congress assembled. It said the plenipotentiaries were representing the United States in Congress assembled. And so thereby, once the treaty was signed, they had to come back and create the trust known as a document, which became the Constitution, which they agreed to service the debt.
I know, and my whole thing about claiming anything under this Constitution means that you're agreeing to service the debt. Going back to this anyway, even with the amendments, right. And who do those amendments apply to?
The signatories and their posterity.
Exactly. So they have the right to free speech. They have a right to this. It has nothing to do with anyone else.
Well, if the Constitution was still applicable, I would agree with that. But I don't even think the Constitution is still applicable because, Congress has already said it hadn't been operating out for over 70 years.
Well, they keep wanting to regurgitate this document as if they had some standing to be able to regurgitate it.
They're not party to it. I mean, Barron versus Baltimore says it. Paddleford versus Savannah says they're not party to it. And if they can't take two witnesses such as that to prove the point, I don't know what to tell you. The 9 cases I gave you in reference to the standing of the parties to be able to state a claim prove that they don't have any ability thereto. And like I said, the show must go on in relationship to servicing the debt. And even though the parties who are signatory in their posterity have learned to shift the debt to others who have no standing to state a claim or otherwise, according to the 14th Amendment, okay, which shifted the burden to accept to service the debt with the only right, if you want to call it political or otherwise, to vote. And it's very interesting that they had to adopt an amendment to vote for people who already assumably had it. And then because, they had to adopt another amendment, the 15th, to give them the right to do so, right?
Mm-hmm.
Okay, so anyway, people just want to see what they want to see, brother. That's all there is to it. But my point is, so they get the right to collect the debt on their backs to give them the right to vote, and their vote doesn't count anything because they're under limitations, restrictions, or reservations in relationship to exercising that right to vote. By the way, they never changed the Constitution in respect to who really puts the president or the vice president in office, the collegiate college or whatever. So the delegates still do it, even though it's a hidden sense. The Senate is still responsible for doing what it says under Article 12. But that's besides the point. So anyway, my point is here, if you cannot see the fact that you don't have standing, there's nothing that you can change. You've been indoctrinated. You're going to believe it to your own destruction. That's your business. You're not going to change anything. Those people who believe they can change something that sits and they have no standing to state a claim, well, they're just, I don't know what to tell you. Can I use the appropriate words, deluded?
Well, that's what you said the other day. If you can't accept the fact that you were lied to from the time you were born.
Pride stands in the way, and boy, they pump that up every day for them, don't they?
Well, then, I'm hearing about people going to take back counties.
Oh, yeah, right.
Take back as if they owned it. They don't own it.
No, they don't. Ownership is in the state. Where does that? Where haven't they read that?
Well, that's what it says.
Record?
Yeah, Senate Resolution number 62. All ownership is in the state.
Better believe it, bro.
Of course, they're going to say that that's all done by a bunch of criminals.
Well, I suppose they have standing to be able to state that when the obvious facts and relationship thereto by contract language states they're not signatory, nor are they one of the posterities in relationship to the signatory authority creating such, gives them such standing to state such claims.
Well, I agree, and it says, it's so succinct in the Paddlefer case.
Oh,
the Constitution is a compact, that's true. And it's also true you're not a party to it. States are parties to it, and they can complain.
And we're talking about private individuals not being a party, right?
Exactly.
Right.
And the point about that is they're not even private individuals anymore. Even in the Treaty of Paris, when they acknowledged the states as being sovereign, it was the states in their collective capacity.
Oh, yeah, absolutely.
Not in their individual capacity.
They don't recognize individual sovereignty.
Well, not only that, when I looked up that review that the three-judge panel did of the Dones versus Penhallow case way back in 1792, they specifically said in there that all private property ownership was in the states, and all public property ownership was in the United States, or in the hands of the United States Congress.
Right, there you go.
So if all private property ownership was in the state, what's that got to do with the individual?
What right do they have to talk about the county?
Right, because the county's owned by the state.
I cannot help that the misrepresentation and fraud that's heard in the centers of education throughout what is known as the states, so to speak, which most people find themselves of in whatever jurisdiction called the United States. But the point is, they did it because they wanted to shift the burden of the debt. They want to service the debt, but they don't want to have the liability of paying the debt. So that's what they did to do it. Do you blame them?
Well, no, if the people were dumb enough to accept it.
You got it, brother.
That's why I said in that presentation I did, the 90 minutes, no one wants to hear that part. I said, look, if you want to accept this liability of the constitutors and make yourself an agent of the constitutors or a constitutor yourself, then pay the debt, and debtors have no rights, none.
Because in there in the 14th it says what? You will not question the debt, right?
Exactly.
There you go.
And if you do question the debt, you are guilty of insurrection and rebellion.
You better believe
and
it.
anything that we spend to crush your insurrection and rebellion.
If you want the right to vote, we want general power to take whatever we want from you.
Right.
That's basically what they did.
Well, the thing is, when it says if we have to spend any resources whatsoever to crush your rebellion, we're going to charge that back on you too.
Oh, absolutely.
That's exactly what it says.
Generations as well, because you are not recognizing the fact that you cannot conceptualize any other situation to get out of this because you're too susceptible to indoctrination, and you've not proved yourself worthy to come out. And if you're not willing to come out then and present your standing in relationship to assuming your equal station among the powers of the earth to which the laws of nature and nature's creator entitle you, then be its slave and be happy with it and stop complaining, because power takes its ingratitude the wreathing of its victim.
How can you be any more plain? The Oregon Constitution...
Oh, that's real plain.
Men, when they form a social compact, are equal in right. When they form a social compact. When they don't form a social compact, then they don't have standing because they haven't pledged to have standing to do anything.
They haven't pledged their honor, their wealth, and their names for nothing, have they?
Of course not. And that's exactly why it baffles me. It says it in their declaration. This is what we're doing. We ain't doing it for you, but if you want to do what we did...
And they witnessed each of them doing it. They didn't witness anybody else doing it.
When they went out and borrowed the florins and rose up their military, and then the military rebelled against them when they didn't get paid.
Right.
Well, if those men had pledged their lives, fortunes, and sacred honor, they wouldn't have been rebelling.
No, that's correct. They'd have been out there fighting harder, right?
Exactly. Instead of worrying about what their paycheck was as a mercenary army.
You got it. You said it. That's why they went into hiding in Annapolis and did something else. You know what they did? They went and treated with the king to get a treaty of peace and say, okay. Apparently, the incompetence and the insanity is running amok here, and we've got to find a way to control the incompetence. Now we have to sue for peace. That's true, brother. I mean, you can't deal with the herd. The only way to deal with the herd is to herd them.
That's called the whip, right?
You know it. Where there's a whip, there's a way.
Yeah.
I cannot help. That's what we're trying to do. We're trying to create order in a peaceful way for ourselves. We're not trying to do it for anybody else. We have no desire to be in collusion with incompetence. You do realize that, right?
Well, I know. That's why it says for those men of goodwill.
You got it.
For men of goodwill to...
What's the sign of being a man of goodwill?
Pledging in a suit to assume his separate and equal station among the powers of the earth as entitled to him.
Nothing else. People don't realize this is contract. Let's hypothetically say somebody at one time wrote it in stone because they were so brain dead. Okay, everything has been verbal up to this point. Apparently, I have to put it in stone for you guys to understand this is an agreement, this is a contract. And if you don't do this, and they were required to read that law all the time, correct? To remind them?
Yeah, they had to wear it on their forehead.
Better believe it. So my point is, if they can't accept 5,000-6,000 years of history of what, it's like everybody. I don't care where they are in business. It really astonishes me. You got people running around a business who think they know what business is.
Right.
They think they own something. I can prove fact that you don't have nothing. You don't have diddly squat unless you pledge to do whatever to create something to be able to have standing to state a claim in relationship to what you believe you own. But they parade around as if they're competent. But we know those without standing are controlled by such policies and procedures and regulations and statutes and codes because they're incompetent. That's why they have to have corporations. Because to do business, the state has to give you permission because they know you're incompetent, and they've got to have regulations to control you when you do stupid stuff. Because you haven't pledged to do anything otherwise than just do stupid stuff by coming to them and getting permission when you already have the power at your fingers to do what is necessary to acquire standing. But since you just want to go along to get along, you're too chicken shit to do otherwise.
Oh, I just got an email about Leroy Schweitzer's video.
Yeah, okay, whatever.
Leroy was with you, right?
Yes.
And Leroy didn't get it either, did he?
No, he didn't. He just didn't get it. And it's not like saying, I was doing the same thing, brother. I was under that program, too. But as time waned on around 97, 98, I was beginning to come out of the program because I was seeing what was going on. I wasn't going to hit that wall again. Period. Something I had to admit, because of the facts that were going on around me, that I had been lied to. That was the only answer that made sense. I had been lied to. I had to give up my pride and say to myself, well, if I've been lied to, I've been willingly lied to, I've been duped by role models, teachers, preachers, patriots, whatever the crap is out there spewing this garbage. I have been lied to. And at that moment did I begin to see the light. So if their pride is too great that they cannot admit that they have been lied to, they will never acquire standing to be able to state a claim for which relief can be granted, and they will always be subject to outside control.
Yeah, well, I mean, how can you get any more claim than the Jamestown Exposition?
You better believe it.
If men aren't willing to self-govern, then they're going to be governed from the outside, period.
You better believe it.
And that's just the way it is. The thing about it is that I'm not unpeaceful about this. We talk about this all the time. We don't care what they do. U.S., I don't care what they do. Somebody told me
As long as
yesterday.
they keep an agreement with us, what do we care what they do with others who are incompetent? That's what their job is, to control the incompetent.
Right.
Isn't it?
Yes.
They're servicing the debt, right?
Exactly.
What is the debt? To control the incompetent. People have got to realize that they've been lied to. That's the whole crux of the matter, brother. If they can't read the facts of which we put out in the book some time ago, which you've extrapolated and used in respect to other things, they're not going to see anything else. They can't even accept what's put before them. If they're not willing to do the research themselves, what is it about these people that they don't forget that they're required to test all things? And testing all things means you must do the research. And if you're not willing to look at the research and test the research, then what does that mean? You're not fulfilling the obligation to test all things? Then if you're not willing to fulfill the obligations to test all things, then you're not, one, willing to accept responsibility. And you cannot accept responsibility unless you're willing to test all things. So stop complaining. And go back to being a slave and do as I tell you.
Yeah. Or as they tell you.
Well, you understand what I'm saying.
Yeah.
Do it.
It's just like I wrote in that document on the historical perspective of self-determination. Every nation on this planet exists because of the right of self-determination.
Absolutely.
And when men had disagreement and they couldn't get redress within the construct that they were living in, then they decided, well, I guess it's time to form a new construct.
Yes.
This whole formation of the new construct is nothing more than asset protection. But that's the reason why these so-called founding fathers, who aren't the fathers of them that they think they are, that's the reason why they did it. They did it to protect their assets. And they were
safeguard their liberties.
And their property.
Got it. And the property was what? What the laws of nature and nature's creator entitled them. Their equal station. What one makes with his own hands?
Yes.
Or one acquires otherwise with his own mind and hands? That's your equal station? The ability that you're given to be able to acquire property? Agreements to keep the peace, to maintain such property? A wonderful conversation on what the hell common law is. Common to those who create anything, not to those who presume to trespass.
Well, I know. The common law is created by those constitutions and charters and contracts.
You better believe it.
Yeah, and then we got to get into an argument about which common law we're talking about now.
No, I don't want to go there, but because common law, once again, I don't even have to get in an argument. Show me the contract, and I'll show you the common law.
Scottish, English, French, Chinese.
Yeah, right. Show me the contract, and I'll tell you that's the common law of that, that's the common law of that, because it's common amongst those who are signatory thereto, or the beneficiaries for which they establish it in relationship therein. The signature is attached to it unless you can, prove that you're, in direct line relationship thereto for the benefit thereof. You ain't got squat. Simple as that.